right.
Thank you, Commissioner. Good morning, Commissioners. Director Bonham. My name is Will O'Dyer. I've worked in law enforcement for 30 years in the state of California. I've worked very closely in a rural area with your wardens, and I've discussed this regulation with them and wanted some of their input on one of the two issues that I wanted to address. Second one is that part of the proposed regulation is a condition as of participating in falconry that we're essentially being asked to waive our Fourth Amendment rights for search and seizure. Having worked in law enforcement for a number of years, it's been always an issue that we have probable cause before we go on someone's private property, search their home, their premises, looking at their records and files. This proposed regulation allows wardens without notice to come onto our property, to inspect our facilities, to go through our records. I feel this is something that is of great concern and may expose the department to potential civil litigation and civil liability. And a lot of our decisions in law enforcement are always predicated upon being concerned about potential liability. I think that you should direct that this provision be stricken, that if they're to inspect a facility, that it should be based on probable cause. I have no issue personally that if someone's doing something wrong and it comes to light, and those officers and wardens develop probable cause, they can get a search warrant and appropriately execute that search warrant and take appropriate legal action. But warrantless searches of our facilities without due cause and without due process, I think is a violation of Fourth Amendment rights. Thank you very much.
Thanks for those comments, but we need to clarify the point about the Fourth Amendment. As a former law enforcement officer, you should know that I think that's an inaccurate characterization of the legal authority here. When an activity is permitted, there's no probable cause needed to inspect the facilities, and in my experience, the only inspections that really matter are the ones that are unannounced. But Mike Carrion,
if I may, I wanted Mike to make comment here, because for those of you who may not know, our wardens do have that authorization at all times, in all areas. But Mike, why don't you comment about that?
Yeah, I understand what the the content of that, as far as general law enforcement work goes, that warrants are required in order to do inspections. However, because of the public resource and the fact that if you made an announcement that you're going to come in to inspect a permitted facility, you would never know if violations were to occur. So there is a different level of authority given to wardens when in enforcing the Fish and Game Code and regulations of Title 14, specifically given under the authority of Fish and Game Code 1006. Inspection authority there is given only to wildlife officers. That does not go beyond our group, so that it isn't abused for just searching for anything, but specifically to making sure that the resources are protected. So that inspection authority is given in the code.
Yeah, I absolutely understand why a former peace officer would not understand that we had that authority, because you didn't.